Here's one mistake that some employers who get sued for overtime violation under the FLSA make. Number one is that they are fighting jurisdiction. So when they get served the lawsuit, they will consult with their lawyers, find out what the options are. And when they hear from the lawyer that, hey, one of the options is you can file a motion to dismiss for lack of personal jurisdiction, meaning plaintiff or a group of plaintiffs has gone to their home, the headquarters, their home state, where they are headquartered, even though they do business nationwide, and sued them there at their headquarters. And so it's provided for under the Federal Rules of Civil Procedures. You can sue an employer where the action took place or where they're headquartered. So when they get served with this and they talk to the lawyers, they usually will find out what their options are. And when they hear that they can file a motion to dismiss challenging jurisdiction, meaning they'll make an argument, look, I am in Delaware. I've never had contact with people in Texas, Colorado, New Mexico. They make that argument, even though they're sending workers there or they're hiring and paying workers there in those states. They try to make an argument that they lack personal jurisdiction actually in Delaware, their home state, because they didn't do any violations there. They just did it in other states or across the country. So that's an argument that could be made. Now the question is, should it be made, and is it a mistake? The answer is, yeah, it's a mistake, because you're only kicking the can down the road. It doesn't eliminate the lawsuit. It just basically say, don't sue us here, sue us in the state where we violated the FLSA. Or the implication is that, yeah, you get a respite. The plaintiff's lawyer will have to file a response. You get a hearing, and then you 50-50 or maybe 60-40, you may lose. But you sued again if you do succeed. So it doesn't make anything any better. So I'll share with you a story. I had a call with a group of defense lawyers on the other side of a collective action overtime lawsuit that I filed under the FLSA and the state wage and hour law for unpaid overtime. And when I asked them why are they moving to dismiss on jurisdiction, it doesn't address the merit of the case. It just determines where the lawsuit should be filed. Their response was that, yeah, the client gave us marching orders. It was one of the options, and they elected to take that option. So they even acknowledged that it doesn't make the lawsuit go away, and we would have to work on resolving it later on. But it's billable hours. Some defense lawyers like to do that. They don't like saying no to their clients. So that's why I think these kind of mistakes will and continue to happen. Okay, back to work.